Hi, everybody. I'm Doug Robinson. I'm the 2021 chair of our Employee Benefit Law section of the State Bar of Georgia. We're fortunate today to have Speaker John Hickman with us, who's going to talk about recent developments in health benefits law. This is a topic that John has spoken on for about 10 years in a row during our live ICLE seminars on employee benefits law. As you know, we haven't had one this year or last year due to COVID. So John's agreed to fly solo today. For those of you who, let me give you one other piece of information. For those of you participating with us in the webinar today, I can confirm that we have been approved for 1 hour of CLE credit. For anyone who doesn't already know or isn't familiar with Mr. Hickman, he's a partner at Alston and Bird, where he's head of the firm's health benefits practice. He supervises a team of attorneys dedicated to healthcare reform issues under the Affordable Care Act, HIPAA privacy matters, health savings accounts, and consumer-directed healthcare matters. Mr. Hickman has worked closely with health plans, financial institutions, employers, the IRS, and the Treasury and Department of Labor, addressing health benefit issues. His accomplishments include being inducted into the American College of Employee Benefits Council, and he's also, in 2016, was named Lawyer of the Year in the area of employee benefits and ERISA law by the publication Best Lawyers in America. Among other things, he is a co-author of several published treatises in areas that include cafeteria plans, HIPAA portability, privacy and security, and consumer-driven healthcare plans. But most importantly, he has a gift for presenting this topic in a way that's relatively easy to understand and very interesting, even for litigators like me. I know he has a lot of ground he wants to cover today, so with that, I'm going to turn it over to John Hickman.
Okay, thanks, Doug, and everyone, thank you for joining us. I do want to mention at the top end, I am presenting from the road, and thus we have the somewhat casual shirt on today. It is Georgia colors, although I do have long pants that are yellow and black text, so you know we've got everybody covered here as well. I want to thank you for joining us. We typically do this in March of every year. And one of the benefits of doing it in March is we typically by then have seen how legislation has affected benefits in the current year. Because we're going to catch you all up for about 18 months of developments, we're going to go pretty fast. You'll note that the slides, especially with some of the new topics, surprise billing, are quite detailed. We'll touch on every topic and the important points will be highlighted. But I will mention there's a lot of detail on the slides that we may not touch on, and the slides are there for your background, for your reading as well. In addition, at the end, and I'll get to it at the end, we've got a real quick, lest we forget the 2020 development, since we didn't get the 2020 update, and we'll cover those very quickly at the end as well. So I want to thank you for joining us. I want to jump right in. We do have a questions panel, so please add your questions. We'll hit as many of those as we can at the end of the session today. So let's go ahead and move on. Okay, I guess there we go. So what topics are we going to cover today? Well, we'll start first with the constitutional case. It's not often that we get a case that addresses a benefits topic, and even less often that the Supreme Court addresses a health benefits topic. So we'll start with that, and then we'll drive right into surprise billing, a discussion of the outbreak period, which we all would hope would end or end soon, but still impacts health benefits in particular. We'll talk about the COBRA subsidy, the ARPA subsidy that is coming to an end very soon, in fact, in just another week or so. And then we'll talk about the other Consolidated Appropriations Act 2021 changes. And there are a number of changes here. They're all statutory. We're starting to get some regulatory and sub-regulatory guidance. We'll touch on those, but in many cases, as counselors, advisors, we're telling our clients, look, good faith compliance is best we can do. We just don't have significant guidance, and the agencies are just working as hard as they can to get on things. We'll then talk about a very timely topic, guidance that's impacting COVID testing. And again, my focus is on the benefits issues. I always work with my employment lawyers, my OSHA and workplace employment lawyers, but I'll cover the benefit impact of various COVID vaccination and testing incentives or surcharges, depending upon which side of the coin you look at. And then, as I mentioned, we'll cover our end of the year recap for 2020, make sure we didn't miss anything. Okay, we looked at 2021. We thought there's a huge Supreme Court case. They're finally going to address the constitutionality of the Affordable Care Act again for the fourth time, I believe. After the first three times, when we just spent lots of time trying to figure out what would change if the Affordable Care Act went away, this time we kind of sat back and said, is it really going to go away? And the Supreme Court decided on a standing issue that the states that were challenging the constitutionality of the Affordable Care Act did not have standing, and therefore the lower court decisions, the Fifth Circuit decision, was reversed. So in that regard, the ACA continues as it always has. We still have reporting requirements. We still have coverage requirements. We still have the pay or play sledgehammer type tax. Nothing has changed. Okay, the Supreme Court again has upheld the constitutionality of the ACA. I think enough said. There are lots of constitutional issues, but for me, in my pointy-headed health benefits world, it's kind of business as usual, just the same as it was last year in going on. But I think the big development as part of rolling into 2021 was the Consolidated Appropriations Act, or CAA 2021, came out in December of 2020, and that gave us a whole host of new health benefit compliance requirements. And indeed, I would say it's the most significant change in the health benefits area since the Affordable Care Act. And we'll talk about these requirements throughout the presentation today. But the first one we'll touch on is surprise billing. Now, there have been a number of states, Georgia is one, that have passed surprise billing provisions, and essentially provisions that say, look, if you end up in the emergency room or you have care that is provided and that care is provided, let's say, by the anesthesiologist, where you don't really have the chance to object and request an in-network provider, there are limitations with regard to what can be billed, and alternatively, requirements imposed on the health plan or health insurer with regard to the amount that they must pay. Well, these developments had occurred in 12 to 14 states, and finally, the federal government got involved and has given us now, as part of the CAA, surprise billing requirements that statutorily were passed back in December of last year. Well, we finally got interim final regulations addressing some of the issues. We don't have all of the issues. One of the big outstanding issue is how this independent arbitration or review, they call it sometimes baseball style arbitration, will occur with regard to the rate paid to providers. But I think much of the plan structural issues we've received as part of the first set of interim final regulations. And basically these regulations confirm a few things. They identify what emergency services and non-emergency services, and now with a further set of regulations, air ambulance services, are going to be subject to the protections of these provisions. And when I say protections, it's kind of in the sense of the participant or the consumer's point of view. Basically, if a mandated amount is paid, the consumer's out-of-pocket is fixed. They will not receive a surprise bill or balance bill. And then the rest is to be kind of beat out between the health plan and the provider pursuant to the statutorily prescribed method. So we know or will know what an emergency service or non-emergency service subject to the Act is. We'll know what the participant cost share amount is, and we'll also know how the provider payment will be calculated. Again, some of the dispute resolution guidance still forthcoming. And we'll also know that the patient protection provisions, the original provisions that had applied to emergency room care under the greatest of three requirement under the ACA, those are now expanded and are going to apply to a broader set of services. We'll talk about those, but key point here is previously under the ACA, if you had a plan that was a grandfathered plan, that plan might be exempt from the patient protection provisions. Well, under the No Surprises Act, they would not be. So we're still waiting on regulations on the independent dispute resolution process. There are other aspects we'll talk about later in the presentation related to price transparency, price comparison, ID cards. We'll pick all those up in just a bit. But let's go ahead and talk about the surprise medical bill provision. And basically, if a plan provides benefits with respect to services in an emergency department or hospital, these requirements will apply. Now, must you cover emergency services? Answer is, well, if you're going to be an ACA compliant plan, yes. There are certain benefits, let's say accepted benefits, dental, vision, some of the hospital indemnity plans that are exempt from this requirement. But if you're an ACA covered plan, Affordable Care Act covered plan, you've got to cover emergency services. And if you do, you've got to comply with the No Surprises Act provisions. Okay, moving on. Well, what do they apply to? Well, they apply to emergency services. And unlike the ACA, which listed emergency services and restricted it to services that are provided in a hospital defined for Medicare purposes, this expands it a little bit further. You might have a situation where services are provided in an urgent care center, and that urgent care center for state licensing purposes is licensed and treated as an emergency care provider. If we've got that type of situation, then that urgent care center and the emergency services it provides would be subject to the No Surprises Act as well. And we've had or seen a significant amount of litigation under the old ACA greatest of three requirement, where emergency room bills that were incurred in urgent care centers or facilities that were not a Medicare hospital, were not necessarily subject to those requirements. Well, again, this now becomes an issue of state licensing, and in many states, the emergency service in the urgent care center will be treated as an emergency facility. So emergency services are appropriate, include appropriate medical screening as defined under the Social Security Act, similar application to the urgent care center, the IFED, within the capability of the facility, and this would include some ancillary services, more on that in just a bit, and also further medical examination within the capabilities of the staff, regardless of whether the person is admitted to the hospital. So this could include, for example, stabilization services. And so basically, bottom line here, this means that the scope of emergency services has been expanded beyond what it typically was under prior law, under the Affordable Care Act. It would also apply, for example, to additional services. And these are services that are otherwise covered by the plan that may be furnished by an out-of-network facility or provider after stabilization. Apparently, this would not apply to in-network services as part of the outpatient observation or an extended outpatient stay with respect to the condition that related to the emergency. What is an emergency medical condition? Significant guidance here. It's medical or mental condition that is in acute symptoms of sufficient severity. And here we now have a prudent layperson definition. This was part of the Affordable Care Act, but there's services that a, quote, prudent layperson with average knowledge of medicine could expect the absence of care to result in immediate medical attention, to result in jeopardizing their health, a serious impairment of bodily functions, or a serious dysfunction of any bodily or organ part. So this is a objective determination based on a facts and circumstances review, but it's kind of based through the eyes of the patient, the prudent layperson patient. And in that regard, this is a significant, I think, aspect that they did address in the regulations. I've got a little bit of guidance down further, but basically, there were some health plans, some health insurers that were determining whether or not a condition was an emergency based upon diagnosis code. And so if you had a diagnosis code, maybe a minor nose sniffle, that might not be categorized as an emergency based solely on that code, and that will not cut it based upon the language in the regs. Based upon the language in the regs, there very well could be a situation or case, well, that sniffle, if it is in the belief of the individual objectively that they've got something much more serious, perhaps COVID, that it could warrant an emergency service, that could result in coverage under this provision. So in emergency service, what are the terms and conditions of emergency service? Well, it's got to be covered without regard to whether the provider is a participating provider, okay, or a participating facility for that service. So for example, a closed network HMO, if it's an emergency service, would have to extend coverage, even though the individual may not have other coverage for other medical services outside of the network. Again, the emergency medical condition cannot be limited solely on the basis of diagnosis code. It's also can't be limited based upon the timing of the onset of the condition and the emergency room visit. And then also cannot be determined with, it must be determined without regard to any other plan, term, or condition other than an exclusion or coordination of benefits, an affiliation period, or cost sharing under the plan. Coverage terms and conditions, a plan cannot impose any administrative requirement or limitation that is more restrictive than its in-network limitations. Cost sharing cannot be greater than participating providers in network. The cost sharing has got to be calculated based upon the recognized amount. We'll talk about the qualified payment amount in just a minute, but that's really what's going to be the driver here. And once that amount is determined, then that's got to be counted towards the individual's out-of-pocket for MOOP purposes. So what is the recognized amount? Well, basically it starts with a three-part definition. In a state that has in effect a specified state law, it's the amount that's determined under that state law for insured plans. And here in Georgia, we do have a specified state law. So in most cases, for most insured plans, that is going to be determinative of what the recognized amount is. If the state law does not have an effect, for example, self-funded ERISA plans, then it is the qualifying payment amount. We'll talk about what that is later, or billed charges. Now, there are some states that have an all-payer model agreement. For example, Maryland comes to mind. In those states, it would be that amount. So what is a specified state law? It means a state law that provides a method for determining the amount to the extent such state law applies. So again, typically not applicable to an ERISA plan, but there is an opt-in provision, which essentially allows a self-funded plan to say, hey, we're not going to administer the qualified payment amount. We're rather going to look to the state law, and we're going to opt in. And if a plan does opt in, it does it for everything that the state law applies to. So for example, if you had a state law that would apply to, I'll just make this up, emergency care and chiropractic, if you opt in, chiropractic would be subject to the state law, even for that self-funded plan. So you get a bill for an emergency services. By the way, the effective date of this provision is plan years on or after January 1, 22. So that's a rolling effective date as a plan comes up for renewal. Some plans it'll be effective immediately. Some plans, fiscal year plans, it'll be effective later when they renew on or after January 1, 22. So you get a bill for emergency services. What happens next? Well, within 30 days after a clean bill is received by the provider, the plan has to determine whether the services are covered, and if so, send the provider an initial payment notice, which reflects how much the plan intends to pay. What is that initial payment? What's the amount that the plan believes is reasonably appropriate based on the circumstances? And by the way, it is typically the starting point if you go into the dispute resolution provision. In addition to emergency services, this applies to certain non-emergency services, provided the plan covers it. And that could include, for example, diagnostic services such as radiology, laboratory services, provided in connection with the emergency treatment, items and services provided by a non-participating provider, and items or service that are furnished as a result of an unforeseen urgent medical need. So if this provision applies, what happens to coverage? Well, the cost sharing cannot be greater than the cost sharing that would be applied if the plan were negotiating with a participating provider. The cost share counts towards MOOP. The cost sharing requirements have to be calculated based upon the recognized amount, and it's got to be processed in 30 days. This does apply to air ambulance surprise bills. There's been a lot of litigation over air ambulance bills. Are they excessive? Are they too high? Is the plan's reasonable customary rate? Should that be respected? So this is brought in as well. And what makes all of this work is this concept of the qualifying payment amount. Now, the qualifying payment amount, again, outside of the all-payer model agreement and states that you're looking at the specified state law. So for self-funded plans that don't opt into the specified state law, it is the median of the contracted rates recognized by the plan on January 1, 2019. So it's back 2 years for the same or similar items and services provided by a provider in the same specialty and the same geographic region. Okay, so how does this compare with what we have today? Right today, we've got the Affordable Care Act. The Affordable Care Act requires that for an emergency service, the greatest of three be paid. What is the greatest of three? Well, it's the greatest of Medicare rate, the median contracted rate, or the reasonable customary amount typically paid by the plan for out-of-network services. There's a lot of overlap here, and I think in a lot of cases, the QPA is really going to be what would be paid under the greatest of three. It's that median contracted rate. But keep in mind that the scope of the No Surprises Act is broader. Again, it applies to grandfathered plans. It also applies to ancillary services and certain additional services as well. And so, you know, we've got kind of a greatest of three requirement on steroids here. What is the IDR process? Again, that's the process by which they refer to it, you know, oftentimes as baseball style arbitration. The plan picks its expert, the provider picks their expert. Between the two of them, they pick a third expert, and they figure out what amount should be paid. All of that happens in the background because once that qualified payment amount is set, the individual, the patient, pays their co-insurance, their co-payment, and they're out of the picture. And then afterward, if there's any adjustment based upon the IDR process, let's say it goes up, the provider gets paid more, that's on the plan. There's no balance billing back on the individual. And we've got a note here, surprisingly detailed. They thought about this issue when the statute was passed. It's actually in the statute, but they had some concern that, you know, if you have this post-treatment payment by the plan without regard to the deductible, because after all, the individual's amount was fixed based on the qualified payment amount, that increased payment that is beyond what is initially determined is not going to blow up the HSA or cause the HDHP status to be disqualified. So there's a lot going on here. I want to mention, it's emergency services. If you're in the litigation arena and you're litigating either for a provider, for a health plan, with regard to emergency care, now ancillary care, now certain additional services, keep in mind that this is going to change how this all works. There is the mandatory IDR process. There is a requirement that the provider, if they object to rate, that they object within 30 days. And if they don't, they're kind of stuck with the amount that is originally proposed as the recognized amount by the plan. So if you're in this area, big changes on the horizon, you want to read these regs, get to know these regs so that you can counsel either your plan or your provider clients accordingly. Let's talk about COVID. I wish we weren't. Wish we didn't have to. In fact, I'm so happy that this is an online webinar. I've got a live CLE event in 2 weeks on the West Coast, and they told me that I had to wear a shield. And I thought, gosh, I hope it comes with a windshield wiper for the shield as well. But let's go ahead and talk about the outbreak period guidance. What's this all about? Well, it's been with us for about 2 years now. The DOL originally issued guidance back in 2020, in April of 2020, that basically put a hold on the running of certain plan time periods. And this is not just health plan specific, it would apply to qualified plans, pension plan claims as well. But in the health plan arena, it's the period for notifying the plan of a HIPAA special enrollment, for making a COBRA election, paying a COBRA premium, for filing a claim, an appeal, an urgent appeal, an external review request. All of those time periods are told, the running of those time periods are told. And the original guidance said, well, until 60 days after the end of the national emergency. And so when that guidance came out, we all expected COVID to be, once and done with. We were all going to, take 2 weeks to bend the curve, and everything was going to be well and done, sometime in the summer of 2020. And of course, that didn't happen. Well, the original notice included some examples. The examples included time periods, but nobody conceived that COVID would take so long and the guidance would need to extend further. But there was one little glitch in the statutory provision, the ERISA provision that allowed for this guidance. It essentially provided that it would not extend beyond a year. And so many of us were kind of looking at the clock and saying, well, gosh, the original guidance was effective February 28th of 2000. That means all of this outbreak period stuff goes away on March 1st of 2001. And we've got a couple of examples of how you count that outbreak period, extending the COBRA election period, how that works. But effectively, we sat here in 2021. We said, well, the guidance is almost over. The 60-day clock will start. And what are the agencies going to do? Well, the agencies gave us further guidance, a new notice that said, by the way, that 1 year time period doesn't roll based upon the calendar for everyone. It applies individually based upon the specific event that you're looking at. So if you have a time period to make it a COBRA election, you've got 1 year added to that time period. If you've got your own time period for making a COBRA premium payment, it's 1 year added to that end of that time period. So it's an individually determined time period, which in no case will be more than a year, but will continue until the earlier of 1 year after the original deadline for what you had to do, or 60 days after the announced end of the emergency period. So you basically start with the original due date, add a year, and that's your new due date. Okay, so if you had to elect COBRA prior to May 31st, 2020, meaning typically you were terminated qualified event 60 days earlier, your election could be extended until May 31st of 2021. If you had a claims run out period that ended on March 31st of 2020, it would be extended until March 31st of 2021, and so on. Now, you would think at this point we would have it all figured out. There's still a couple of unknowns out there. We've got a couple of examples out here. You know, my COBRA election period would have been due on May 31st, 2020. I elect COBRA prior to May 2021. I have 45 days after that to elect the first premium. I don't make that first premium period payment. Do I still have a further time period to make that? And again, some additional questions. So this is a requirement. It's still an ongoing requirement. We still have new COBRA election periods. We still have new COBRA premium payment periods. Fact of the matter is, until we see the demise of COVID, I think we'll continue to see the ongoing application of the outbreak period and what it does. Let's talk next about the American Rescue Plan, or ARPA, American Rescue Plan Act, COBRA Premium Subsidy. Now, this subsidy is based loosely on a prior era, ARR, we had back in the late 90s, and essentially the subsidy provides 100% COBRA subsidy for certain individuals, certain COBRA folks who lose because of a reduction in hours, and that could be a voluntary or involuntary reduction in hours, or an involuntary termination of employment. So if you have somebody that loses coverage because of one of these events, they are an assistance eligible individual, or AEI. Okay, a new acronym we need to put up there. And basically, an AEI who has had a COBRA event that qualify them is able to continue COBRA coverage and to receive 100% subsidy for that coverage for the period of April 1st, 2020 until September 30th of 2021. Now, this is not an extension of COBRA. This just means if you are eligible for COBRA and you could have elected COBRA during that period, then you can have that COBRA 100% paid for. And in addition to providing a premium subsidy, it also allowed what we call a second bite of the apple. Okay, so my COBRA event occurred in January. My COBRA election period ends 60 days after that, let's say in March. And I elected COBRA but didn't pay my premium, or I didn't elect COBRA. I got a second election right under ARPA, and that second election right would enable me to elect COBRA, perhaps retroactively under the look back period under the outbreak guidance, but also to have that COBRA applied prospectively and paid for 100%. Department of Labor was quick to get guidance out. There's a number of model notices and facts about the subsidy, how it worked. And they're very helpful documents. I think they answered a number of questions very quickly that we had. I will note the one here to note, the very last one, the model notice of expiration of subsidy. There is a requirement that on or before the end of the subsidy, the end of the subsidy period, which is September 30th, at least 15 days, but no more than 30 days prior to the end of the subsidy. And for most people whose subsidy is ending September 30th, that would have been September 15th, that they get a notice that says your subsidy is about to end, and there's a model DOL, but basically your subsidy is about to end. You've got the right to continue by paying the full COBRA premium, or you can go on to an exchange plan, yada, yada, yada. Very important to note that if you have not been sending out the expiration notices, or you have not gotten the expiration notice out generally, to make sure you get that out. The IRS had a lot of very difficult issues to address relating to the subsidy, basically who was eligible, what terminations are voluntary, what's involuntary, how about a disability, how about somebody who is forced to resign. And the IRS gave us this guidance in the form of 86 Q&As. It's IRS notice, as we note here, 21-31. And it's broken down into 12 different categories. Won't get into them in too much detail, but if you ever have a question or issue, was somebody eligible for the subsidy, or are they an assistance eligible individual? This is the place to look. This is the guidance that we received. They did follow up with a little bit of additional guidance related to how to apply for the subsidy. Remember, the coverage is free to the individual, fronted by the employer, and then the employer, whether they're a taxable employer or a tax-exempt governmental church employer, is able the subsidy back by filing a tax credit. And the IRS has given us guidance as to how that's done as well. So lots of takeaways here. Use the IRS Q&As to identify whether somebody is in an AEI, what their AEI status is. Remember the second qualifying event or disability extension provisions. Also, there are some employers that have previously paid for coverage. In some cases, the subsidy may step in there for the employer contribution. You want to review the process for claiming the Medicare tax credits, IRS forms 941 or 7200. Very important to, if you're an employer that extended the subsidy but provided the free coverage for the employer, make sure that they file and get their refund. And then finally, keep in mind the deadline for the expiration notice. If the subsidy ends, that you were required or are required to send out a notice reflecting the end of the subsidy. Okay, so we talked about COBRA, we've talked about ARPA, we've talked about the outbreak period, we talked about surprise billing. Just a couple of comments on the FSA, related to the Consolidated Appropriations Act. The act included some very liberal or generous relief for flexible spending arrangements. I will note the word elective in this slide. Much of the other relief, whether it's the outbreak period or ARPA, was mandatory, but this is elective. And I stress that because there are many employers who have kind of looked and said, we just don't have that many people losing flexible spending account, health FSA, or dependent care FSA money. We're not for sure that we really need to dig into those, but just to highlight them for those that have people who may be forfeiting funds. So you put all your money in a daycare spending account, and because you have been working remotely or the daycare has been closed, you have not needed the daycare. There are provisions here that provide relief to employers in these cases. So let's talk just a bit. First of all, there's a provision that allows a carryover of unused FSA funds from plan years ending in 2020 to 21. There's an extended grace period. There's a provision that allows health FSAs that have not used up all their funds to use them up. We call it a spend down provision. Moving on, there's a expansion of the eligible dependent care expenses. Typically, a dependent child who reaches age 13 is no longer eligible. The regulators realize, gosh, if you turn age 13, there's money in the dependent care account and you can't use daycare. We want to allow people to use that, and that allowed for that, as well as a provision for election changes. Just a couple of points to highlight here. The carryover of unused FSA funds applies to both the health FSA and the dependent care. It's for plan years ending in 2020 and plan years ending in 2021. There's no cap on the permitted carryover. I note that typically has a cap. The cap is adjusted for inflation. There is no cap here. If you are using either the carryover or the extended grace period, and you have a health savings account option, you want to make very careful, take great careful steps to ensure that you're not disqualifying your individuals from being eligible to contribute to their health savings account. And effectively, the way that you do that is that you restrict the carryover or grace period amount so that it is limited to vision or dental care. I mentioned the health FSA spin down. I think an important point to note here is that just like the carryover grace period, it will disqualify somebody from being eligible for the HSA. We also mentioned the temporary extension of the dependent child care age to age 13. And then there's some additional leeway. And keep in mind what's in red here. This is for plan years ending in 21. So if you're a calendar year plan, it's up until December. If you're a fiscal year plan, this guidance may have already expired, but it would allow any prospective change to a health or dependent care FSA, as well as additional medical, dental, vision care changes as well. So should you adopt these FSA changes? Maybe. I mean, we do have some employers that were very, very, very centric and made changes. Had others that have looked and said, gosh, there are just so few people that are having forfeitures. The FSA amounts, whether it's healthcare, dependent care, are so low that we're just not needing this relief. A measure of ARPA is the increase in the dependent care spending account amount to $10,500. This is a temporary calendar year 2021 only increase. I stress that because there is some question as to whether Congress will act to renew this for 2022 and beyond. Can an employer take advantage of the increase? Well, it depends on how the dependent care plan is drafted. There are some plans that specifically refer to the $5,000 cap. There are other plans that refer to the statutory provision and say elections can be made up to the statutory amount. And depending upon how your plan changes, an amendment might be needed, or you might have it automatically take into effect. Now, take note that one issue that I think that the increase to $10,500 has brought to light is the non-discrimination test that applies to dependent care FSAs. Those arrangements are subject to what we call an 55% average benefits test. And one thing that we have seen in almost every case where we've opened up the plan to let people elect up to $10,500 is the higher paid people do it, the lower paid people don't. And a plan that might have been in compliance with the non-discrimination test before is no longer in compliance. And so before opening the door to increase elections to bump up to the $10,500 amount, you do want to take care and check your testing. IRS Notice 2126 addressed several, I'll call them pointy-headed issues related to dependent care. Can you get the additional dependent care amounts attributable to the $10,500 increase or a carryover or a grace period? Can you get that as a tax-free benefit? And this said yes, it should be tax-free, notwithstanding some other guidance in the directions. The directions included in the 1040 package. IRS also has addressed the eligibility of PPE expenses for reimbursement under a health plan, such as a health FSA, HRA, or HSA. And again, do you need to amend your plan? Well, it depends. It depends on how your definition of eligible expense is drafted. In most cases, you will. I would not get too upset about a retroactive amendment. You can amend it retroactively to January 1, 2020. And this would allow for tax-free reimbursement of personal protective equipment, masks, hand wipes, hand sanitizer wipes, and hand sanitizing wipes, hand sanitizer for the primary purpose of preventing the spread of COVID. Now, there have been some informal IRS comments to the effect of, a surface disinfectant, the Clorox that you buy and you put all over your counter and grocery bags and in car and everything else. If it's not a hand sanitizer, that it would not be eligible. So, read this literally. I think the IRS clearly is. Question, how do you address the primary purpose? The FSA TPAs are really addressing this. Many of them with their automatic adjudication for over-the-counter drugs, what have you, have systems in place to address this. But, I question, if I go in and buy my N95 mask at the local, home improvement store, and I've always bought it there because I do a lot of painting, is that going to be an eligible expense? I would hope that something in the system would say no, whereas the same N95 mask, if I'm buying it at a Walgreens drugstore or what have you, perhaps could be. So some of the issues, again, that should be looked at in the FSA HRA administration world. I want to touch a little bit on the other Consolidated Appropriations Act. I see we're at the 3/4 mark. Consolidated Appropriations Act provisions. We'll start first with the Tri-Agency Facts Part 49. Basically, what these facts did is it shows the tri-agencies just kind of throwing in the towel at some of the statutory deadlines. They push some back, require that others be complied with, and require good faith compliance and with regard to others. And I want to touch on each of these just a little bit, but first step back for just a minute. Pardon me, take a quick drink break. Okay. First, step back and say, if you're an employer plan sponsor, how do you ensure compliance with these? Most of the time, this is going to be a product of what you have in your TPA administration agreement, your ASO agreement. You want to address these new requirements, or at least attempt to address them with your health carrier, health TPA, because so much of this relates to information that only the TPA has. So there was originally a January 1st, 2022 deadline under which the health plan had to provide machine readable in-network and out-of-network rates for all charges. And basically, they had to put it out there. This is all in the interest of transparency, and under the Consolidated Appropriations Act and the prior ACA transparency regs, that was January 1, 22. Well, the agencies have pushed that back now to July 1st, 22 for plan years that are starting January 1, 22 through June 30th of 22. So it is still here. There's still a requirement the plan make that information available, but because of the technology involved, the requirement to make it available, downloadable, and gathering that information, there is a delay now until July 1 of 22. The original January 1, 22 deadline for providing machine readable, negotiated, and historical price information for prescription drugs has been extended indefinitely. So you say, well, why do prescription drugs get a special deal? Well, when you think about how do we figure out what the net price is if we have rebates, discounts, manufacturer incentives, inducements, coupons, it is as difficult or much more difficult to determine what that net price is. And so that one, they're kind of punting down the road, giving a little bit more time to figure out. In addition to the requirement to provide a list of all the allowed charges, allowed amounts, there was also essentially a price comparison tool. And under the Consolidated Appropriations Act, we call it the Advanced Eob Requirement, where effectively an individual would be able to say, I'm going to have a knee surgery. I would like to look up what the knee surgery is going to cost me based upon my particular plan coverage. What's the difference? Well, on the prior slide, we're looking at, what the allowed amount is for a particular treatment. That's how much the plan would pay in total. But under this provision, it would be effectively how much the individual has to pay out of pocket. Okay, it's the advance EOB. And these have been set back. They were originally due plan years starting January 1, 22 under the Consolidated Appropriations Act, plan years starting January 1, 23 under the ACA transparency. And the agencies have said, we're going to push it all back to January 1, 23 while we figure it out. Deductibles and out-of-pockets have to be showed on ID cards. This is not extended, but good faith compliance is recognized. There's a requirement to update and keep an updated provider directory. And effectively, if a plan does not update its directory, somebody has a treatment at a provider that's no longer a participating provider, the plan has to pay it at the participating provider level. That has not been set back. That's still January 1, 22. Likewise, no delay for a continuity of care if you change provider networks, change plans. That's got to continue. And then the requirement imposed on physicians that they provide good faith estimates. And that's one of the things I think that is going to make transparency work, is still required January 22. That's a provider obligation, not a plan obligation. And that's not delayed at all. There's a gag order prohibition that was effective on contracts or renewals on or after December 27th of 2020. That has not been delayed, so plans still are prohibited from agreeing to administration contracts that have a gag order. But the attestation that was required to be provided by the plans is delayed until December 27th of 22. So again, the agencies have kind of looked a bit. They've extended certain requirements. One of the new Consolidated Appropriations Act requirements that was not set back is the additional fee disclosure requirement. And just putting this in context, this originally came around for health and welfare plans when it came around for qualified plans back in, I believe it was 2011, 2012. And there was a lot of pushback. Health plans, we don't know how to disclose. We don't know what to disclose. PBMs, how would they disclose their compensation? And basically, they have now made this requirement applicable to any broker or consultant that provides any services if they receive $1,000 or more in annual direct and or indirect compensation. And it covers all group health plans. And so that would include, accepted benefit health plans, HSAs, HRAs, EAPs, vision, dental as well. The disclosure is very similar to that imposed upon qualified plans, has a broad definition of brokerage services. So, keeping in mind that for fully insured plans, there's already a commission disclosure requirement, but this would extend to additional services provided to health plans, for example, to self-funded health plans, finder's fees, other provisions as well. And likewise, with regard to a broad listing of consulting services, and this is straight from the statute, Department of Labor has indicated that they don't think that further regulatory guidance is needed. So we're left, again, based upon the broad language in the statute and determining what is subject to it. So, tips with regard to this, identify, if you're a plan, identify all consultants, brokers, who may be subject to disclosure. If known, determine whether they're receiving direct and indirect compensation. Be prepared to include or disclose compensation paid their way. And there you have it. Just a couple more topics, and I see we've got about 7 minutes left. I want to highlight the Consolidated Appropriations Act mental health parity comparative analysis requirement. This is a new requirement which effectively requires that plans make available their comparative analysis to auditors, DOL, for example, state auditors, and participants upon request. The Act requires a written 5-part non-quantitative treatment limitation analysis where the plan has to identify those. What are those non-quantitative treatment limitations? Well, they're things like utilization review, medical necessity, any of those provisions. There has to be a comparative analysis as to how that is determined, the factors considered in designing the NQTL, the evidentiary standards that are applied in determining the NQTL, and that information has to be made available to the agencies upon request. There's a note here, I kind of chuckle a little. Each agency must request at least 20 a year. I'll tell you, virtually every health plan that we work with has seen these requests. And we're in the middle currently of several situations where we're at the second or third iteration where the agency has requested the comparative analysis. It's been provided. The agency has suggested that certain areas need to be beefed up, and you've got 45 days after they find a deficiency to correct it. If the agency still finds that the arrangement's non-compliant, then there's a requirement that the agency have the plan notify all participants that they're out of compliance. If you're not familiar with this area, where do you look? Where do you look for guidance? The agencies have a very in-depth self-compliance tool. I will note that there's not a lot of guidance in there about how to compare NQTLs and determine whether or not it's more stringently applied to mental health than it is to medical surgical, but at least it's a good starting point. And I would encourage anybody who counsels a group health plan, an employer plan, to take a look at this. I think action items, look at this, determine whether you think your plan's in good shape, address these issues with your TPAs. It is important to make sure that you're up on this. The agencies did issue some facts, Part 45 in April. Basically, the facts provide what they expect to see the comparative analysis consist of, and it's replete with statements that conclusory statements are inadequate. Last two topics I want to address: worksite, the benefit aspects of worksite COVID and vaccination testing. There are a number of facts the agencies have sent out, addressing how COVID testing and COVID vaccinations generally are required to be covered. But this gets more at the concept of, if I'm an employer, can I require testing? That's more of an employment issue. Or can I incent people to test or receive a vaccine with a benefit plan incentive? And this, of course, is all kind of highlighted by the recent September 9th guidance. Yes, we sometimes update slides for new guidance, item number 7 here. The September 9th guidance, where President Biden indicated that all employers with 100 or more employees, as an OSHA requirement, is required to either produce negative tests or proof of vaccination. So what are the benefit issues? We've got a number of compliance areas. We've got the HIPAA non-discrimination rules, the Americans with Disabilities Act, the ACA Title VII. We do expect, I'll get kind of to the spoiler alert, we do expect tri-agency guidance soon on the issues of vaccine incentives and surcharges. I will say, if you have not delved into this area, the biggest area of concern, at least for me recently, has been twofold. Number one, type of arrangement very likely would be subject to the HIPAA non-discrimination rules, which means that certain requirements apply. They're listed here on the slide 80. Limitation on the amount of reward, how you apply it, and that you've got to have a reasonable alternative for somebody who cannot complete the requirement, cannot get the vaccine, cannot reasonably be vaccinated. And so you've got to look at that, as well as the ADA and GINA implications. One thing the new administration did is it pulled back some guidance under the ADA that related to wellness programs and how the ADA impacts wellness programs. And I think we have a little bit of a void here with regard to whether some sort of incentive for testing or an incentive for vaccinations may be impacted by the ADA requirements. I will say under the Genetic Information Non-Discrimination Act, if you are providing an incentive for a spouse or dependent to be vaccinated, I do think that you run into some serious GINA issues. Couple of reminders as we wrap down. Remember, this is now 2 years since we last met. There was a lot that happened last year. The Cadillac tax is no longer out there. Health insurance tax no longer out there. PCORI still applies. Remember, under the CARES Act, all of the mandates that we had last year for group health plan coverage of COVID testing and vaccinations. Remember that there is, at least currently, an exception for HSA compatible plans to offer remote care, and that could be a remote physician visit, a teledoc, telehealth visit, what have you. And that exception ends the end of this. It's got to be any plan year adopted before 12/31/21. So for calendar year plans, absent congressional action, it's going to end the end of this year. And so if you have an HSA plan, you want to go back and revisit some of the telehealth and other issues. The regulators did confirm that over-the-counter drugs, as well as certain menstrual care products, were eligible medical expenses. We're still waiting in the health benefit arena for the new Department of Labor electronic disclosure rule to apply. It looked like that was coming through, but still have seen nothing on that. And then just a reminder, as is always the case this time of year, to look for cost of living adjustments. The ones that we have already are up here. The HSA contribution max has been bumped up for 2022. The catch-up contribution deductible minimum are still the same. The out-of-pocket max for HSAs is bumped up. We don't yet have the formal transit, parking, or health FSA salary reduction in carryover amounts. We do expect to see those very soon. They generally come out in October. With that, I want to thank you all for your time. I'm going to check and see if we have submitted questions. Looks like we had just a couple of technical questions. We'll give just a minute or two for further questions to come in. And if there are no questions, we will break for the day. Bear with me. With regard to incentives, do we think that they would be considered an, sorry, let me open up the screen, an activity only or an outcome-based program? I think it's a little bit unclear. I think you want to be conservative on that. I think that you probably want to address that issue carefully. Lane, I think we are at the end of our session. I think in that regard, if there are no further questions or comments, I want to thank you for joining us. Thank you for supporting the benefits section, and hopefully we'll see you in just a few months with a 6-month update. Thank you. Thank you very much, everyone.
Ladies and gentlemen, this does conclude today's webinar. Thank you for joining and have a great afternoon.